I'm here with my guest, Ady Niv. He's an attorney for the International Criminal Tribunals of the UN. Thank you so much for being with us today.
Thank you for having me.
I want to start off by asking you, what are you doing in Armenia for the next 48 hours?
Well, I was invited by the ICRC delegation in Yerevan to participate in, give some lectures in the summer school conducted in cooperation with the American University on issue of international humanitarian law, called those IHL, or the laws of armed conflict.
Right. And you are a co-founder of the Association for the Promotion of International Humanitarian Law, which promotes IHL knowledge in Israeli society. Can you just talk about the roots of the organization and what kind of work you guys do?
Of course. Just if you allow me a small caveat, I have to just to state that as a UN employee, I don't represent today the UN, and my position doesn't necessarily represent the position of the United Nations of the tribunal for which I work. With regard to Alma was born because we realized there was a vacuum in the Israeli society, the need for more knowledge of the laws of armed conflict, IHL, in the Israeli society, especially in the Israel where the issues of the laws of war are something that are in the daily news, are part of the public discussion. Right. And we wanted basically to make the law more accessible to the general public in order to promote fruitful discussion within the society. And just an example, ALBA members themselves come from a variety and very diverse background, legal background and personal background. And we have different opinions, but political different opinions, but is the common language of the laws of conflict that allow us to have a productive discussion, putting political constraint aside. And this is basically why ALMA is an apolitical organization, non-profit organization that has for its main objective the promotion of the knowledge of international humanitarian law within the society. And the way we do it, and I'm just going to give some examples. Yeah, exactly. We have three major educational domains. The first one is direct education. Direct education means providing lectures and workshops to law students from first year to PhDs, and also to non-laymen, people who are not students of law. We also take part in the organization of the competition of IHL in Israel in cooperation with ICRC, and we have a newsletter that we send about events that are relevant for the laws of armed conflict. The second domain is, if you can call it a domain, is basically creating a platform for those discussions to happen. So we have a monthly forum when we discuss events through the prism of IHL, or when a person has an article on an issue you want to publish and you come and have a discussion on this issue. And of course, the website of ALMA itself provide for a place for discussion and people to express their opinion, whether in blogs or articles. And the third is, as I mentioned, we want to make the law accessible to the general public. So one of the ways to do so, we have several projects. One of them is the dictionary. And basically we take IHL or international terms and translate them into Hebrew in a very simplistic and direct manner. Another project we're having is the translation of the ICC Rome Statute, the International Criminal Court Statute, into Hebrew, again, to make it more accessible to the general public and make the discussion more interesting.
Yeah, and as an expert in international humanitarian law, this is very dense, complex material. What are some of the strategies to make that material accessible to the everyday person, like you were just talking about?
Well, I think there's different ways, different approach of education. I think one of them is give examples. Give examples that happen and see how it translates, how those facts translate into legal terms, and what is the signification of that. In those scenarios, people, for example, might say that a certain person it's a war crime, and you explain, wait, why is it a war crime? What are we talking about? And that made it more accessible, have a discussion about something which is quite recent, which triggered the interest of the public and the wish to learn a bit more, and then they have the knowledge for future cases. And this is just one of the ways.
Nowadays, the means and actors in international warfare have changed, and we have an emergence of non-state actors waging wars around the world. What are some of the challenges of enforcing international humanitarian law when you have more and more non-state actors involved?
That's an interesting question. Just as a preliminary remark for the sake of the audience, non-state actors, it's not a new phenomenon in the 21st century. It's not an invention. We had previously we call guerrilla fighters, partisan francs-tireurs that visited the battlefield for centuries. But as you said, there's a growing phenomenon.
Right.
But we need also to understand, this is my second comment, is that international law that address the issues of war is not built in some independent, linear way, but is actually going alongside the developments in war. Some say that IHL is actually, the rules of IHL are forged in the heat of battle or following the consequence. If it was Solferino first, or if after that the First World War, the Second World War, they created Geneva Conventions. These are just examples that IHL is not detached from what happened in the battlefield, and IHL is not familiar with the issue of non-state actor, but yes, it's a growing phenomenon. And one of the problems with non-state actors, it can also be with state actors, but I think personally with non-state actors, is the way they act, their modus operandi, the way they behave in war, and if sometimes even the military success is dependent upon violating IHL rules. Just as examples, sometimes the combatant of a non-state actor or of an armed group might disguise himself as a civilian in order to gain an advantage to execute his military task. Or even worse, he might use civilians as human shields. And this is where we have actually a problem, because it's part of the modus operandi. And the criminal justice system, or the fear of the combatant that he might be prosecuted later on for those violations, is sometimes not strong enough. It's not enough strong factor to dissuade him from from violating IHL. There's interesting study actually of the RCRC called The Roots of Behavior in War, which actually try to do exactly that. Understand what is the trigger, where do we lose the combatant in the compliance of IHL? What is the problems and what is the reason or the roots of violating IHL? And what I take from the study is, I think, two important things. One, the lack of internal discipline within the armed groups. Again, it can be state or non-state actors, but we're referring to non-state actors at the moment. And the lack of dissemination of IHL, the lack of knowledge of IHL within those armed groups. And I think, and this is my personal view, of course, the ways to overcome or try to overcome these problems with non-state actors can be threefold. The first component, as I see it, is dissemination of IHL, is the training of IHL, especially in places, in countries that are susceptible to become war zones, so already in advance. And of course, also important is the training of those who are part of the armed forces. And I think it's absurd today, we live in a world where you have areas where it's easier to get a weapon than a driver license. The second component, I think is also very important, is documentation of violation of the laws of war. You can be a journalist. Today, to be honest, everyone with the mobile phone can document it, and you have even NGOs that assist you on how to document, to register or to load those kind of footage online. You have, for example, the Eyewitness Project that give instructions how exactly to document such violations. And that's also important, and it's important, especially I think for non-state actor, because today the warfare is not conducted only in the battlefield, it's also in the media. And some non-state actors are dependent upon the support they're getting from the population. So if they see that those people violate, they're putting their civilian lives of the same population at risk, that could be a very important factor in dissuading or to give them an incentive to actually comply, to act with compliance with international law. Of course, the other reason that documentation is important is for the third component, and that is for accountability, to make sure that the law is enforced and to avoid impunity.
And is it more difficult to bring a non-state actor to an international criminal tribunal than a state actor? And could you just talk about that process a little bit from your experience?
Well, I don't think there's a difference between, in that sense, too much between non-state actor and a state actor. As far as the legal issue is concerned, you may have talked about other problems. For example, a state refused to extradite someone to the international tribunals. But as far as the legal, the tribunal itself, the prosecution is the same. They both have to abide by the same laws, whether of what's called international humanitarian law, the laws of war. If a person attacks a civilian or uses a civilian, it will be a crime. whether it's done by agents of a state or whether it's done by agents who are not necessarily representing a party of the conflict, but the crime is committed within the conflict, they can be prosecuted similarly.
And you mentioned how there's an ongoing war in the media, not just on the battlefield. And with the recent terrorist attacks in London and other cities, there's been increasing calls from politicians to more closely regulate the use of the internet by some of these terrorist organizations. And I'm wondering your opinion on this, and as a lawyer, what your thoughts are, and what would be solutions to kind of this war that's ongoing in the media.
These are, if I may, two different issues. Is one, the war in the media is the way to basically to win the heart of the population.
Right.
And this could be a legitimate measure. It's just part of today's war with the development of technologies. They're using some parties use all the technology at their disposal, including the media, and showing how they suffer more than the other side, etc. And this is legitimate. What is another aspect, as you're referring to terrorist activities that are conducted via technological advancement, such as could be Facebook or other mechanism. That's a different problem that can be solved either by national, depends on the action. Of course, we say terrorism, but terrorism is not really defined in international law. So either on the domestic level, it can be apprehended by the national authorities. But today, if you use what we call now a cyber warfare in part of war, then we're speaking about a different issue that also it's quite interesting from the perspective of international humanitarian law, the laws of armed conflict. Recently there was published a telling manual that actually it's around 300 pages discussing how the international humanitarian law applies also when to issues of cyber warfare. So when the person is using a computer from his house to destroy, for example, the computers of a military facility belonging to the enemy. So this is another development that is and is regulated, is regulated by international law. But there's two different issues.
I want to switch gears a little bit, and you're a former military prosecutor, and I'm wondering, is it necessary, in your opinion, to have a military lawyer in every army to consult on matters of international humanitarian law?
I might be accused of being biased as a military lawyer, because my answer is going to be yes, absolutely. But we can see also from the origin where it comes from the need to have a lawyer in the army. If you look before the Second World War, the idea was to have military manuals that include the rules of armed conflict, and that was supposed to be enough for the commander to know what to do. The result of the Second World War and the criminal prosecution that followed taught us that no, it's not a sufficient tool. And in the Geneva Convention, you have also the idea of dissemination of IHL. However, lesson learned 20, 30 years later in the additional protocols to the Geneva Convention, there's actually an obligation to provide the military commander with accessibility and access to a military lawyer with whom he can consult. That's the idea, Article, I think, 82 of the additional protocol. So this is where the issue is today. It's recognized as something that has to be in every, the legal officer doesn't have to be necessarily in the army, but it has to have access, the military commander has to have access to this kind of knowledge. And this is what basically you get with a military lawyer, is more knowledge and basically expertise about IHL. And it's important to, first of all, to know that the military lawyer doesn't replace the decision-making of the military commander. He provides the commander a tool, a legal tool, to make sure that his actions are within the boundaries of IHL. And even more important, and this is not only from the law perspective, but from practical perspective, that sometimes in the room when the decision-making, when there's a decision being made by the military commander, sometimes the lawyer is the only person in the room who is capable to tell the military commander what you're suggesting is outside of the boundaries of law and should not be executed. And this is important because in many states, for example, Israel, United States, but from my experience, of course, I'm speaking from the Israeli perspective, the military lawyer is not part of the regular chain of command. His legal decision cannot be overturned by the military commander, but only by the supervisor within the military system, the military justice system. So by, for example, the military advocate general. And that gave him the capacity to be independent and give the military commander the best legal advice without having the fear that if he gives advice that the military commander might not necessarily like, that will affect his career within the army. So that is very important in that sense.
Right. So I want to apply some of your expertise to a local context, to the ongoing conflict in Nagorno Karabakh between the Republic of Artsakh and Azerbaijan. So the Republic of Nagorno Karabakh is a party to the Geneva Conventions, while the state of Azerbaijan is not. And I'm wondering, are there any complexities in that sort of situation when you have one state that's a party to an international convention and the other is not? And from your experience, if you could talk about that a little bit.
Well, first of all, in general terms, we need to understand two things. One, as far as customary international law is concerned, it's not important whether a state signed the specific convention or a protocol, they're still bound by it. And just to explain, customary international law is basically those rules of law that states act according to and see them as obligatory for themselves. So for example, if the additional protocol, and if state A didn't sign it, but additional protocol states that this is the definition of a military target, this is the definition of a civilian target, and you cannot attack one but only the other, and when you even attack you have the principle of proportionality. Those are part of customary international law, and whether one state signed it or not doesn't affect his obligation to follow it. And the consequence if it doesn't follow those obligations and violate it, it might trigger criminal responsibility of those who gave the order. So this is the one thing that's important. The second, when one state is respecting the law and one the other, is that customary international law is not dependent upon reciprocity. In that sense that if state A commit violations of IHL, this doesn't legalize, doesn't make the future violation of state B legitimate. Okay? It's not dependent upon the good faith of the other party.
Right.
Every party has to abide by customary international law regarding arms conflict. And in that sense, it doesn't change whether they signed or not.
Thank you so much for being with us today, Ady. I really enjoyed speaking with you.
Pleasure was all mine. Thank you.
Thank you for watching CivilNet.